So if you use social media either to create content, moderate a forum, or even just comment, you're going to want to watch this, because I'm talking to a real Australian lawyer specialising in cases of online defamation about the risks we run and what you can do about them.
So the first step in a defamation is what's called a concerns notice. You can have a wrong opinion so long as the basis for that opinion is reasonable.
So let's say that I got a letter from a US law firm threatening to sue me in Delaware and I'm in Australia. Could I just throw that in the bin?
A typical court case in defamation could run easily for a week if it's a straightforward, simple case, and that could cost, defames them, which affects their reputation in the eyes of ordinary, reasonable members of the public.
Even though Stefan won, he's not going to be able to recover all of his costs anytime soon, is he?
No, he's not. It's not a total get out of jail free card. It doesn't mean that you can't be sued. The media company was found to be a publisher for the purposes of the Defamation Act, even though they didn't make the statement themselves.
Let's talk about professional indemnity insurance and what that is and other types of insurance. This video is a general discussion around legal matters for content creators in Australia. You should engage your own legal counsel for advice specific to your circumstances.
My name's PK Cruises. I'm a solicitor. I've been specialising in defamation since about 2010. Have run a few cases, primarily defending defamation matters. One of my major clients is a online forum called Whirlpool. So I've had a fair bit of work through them and helping them to avoid being sued.
So we're talking about the risks then. We're going to look at it from three perspectives, which is content creators such as myself who might like not to lose all of our assets. People who are just commenting on social media, what risks do they run? And then people who actually create products and send them out for review. So we were talking before and you said, let's start with defining defamation, which
so defamation is material that's published to a third person about somebody that is either written or spoken or even illustrated and can be on the internet, but it can also be in print media, which identifies a person either by naming them or by inference, that defames them, which affects their reputation in the eyes of ordinary, reasonable members of the public. And as a result of that, they suffer serious harm. Now, so that's primarily individuals. Some corporations can also sue for defamation, but they have to be small corporations of fewer than 10 employees, full-time equivalent employees. And so they're treated like a person in that sense, but they must suffer financial harm. So what's the best practice for content creators who provide product reviews? That's sort of the main area. The first thing to keep in mind is that any statements that you make should be factual and should be able to be backed up, and it strengthens your case if that underlying basis for the statement is published as well. If you're going to say something negative about somebody or somebody's product, then it's always a good idea to give them an opportunity to comment. And that way, you've sort of got both sides of the picture. and they're less likely to sue if they've had a chance to put their case. As I say, you don't have to name somebody. You could put up a picture of them. You could describe them by way of their job or where they work, and that would be sufficient if the public is able to identify who you're talking about, then that's sufficient argument to sue if you've been defamed. The other area is if you're on the receiving end, if you're a product creator and somebody comes to you and says, I want to publish a review and I've got some problems with your product, it's always a good idea to engage and see if you can't work out why there's a problem and see if you can't resolve that problem. It might even short circuit the need for an article, or it might turn the article around in the sense that you might have uncovered a problem with your product that you weren't aware of.
Okay, so just coming back to the point you said, make sure that if you do say something negative, it's factual and backed up.
Yeah.
Would an example of that be, let's say that, I don't know, I had a piece of four-wheel drive recovery gear and I said it's weak and feeble and likely to break. So that's an opinion. I would then need to prove that and say, look, we put it through a brake test and it broke at what would be less, or the material it's made from is X, and normally these materials are made from Y, or there's less material than the usual, something of that nature. Is that what you're saying?
Yes, indeed. And honest opinion is a defence in defamation, but there has to be a reasonable basis for that opinion. So I couldn't just say so-and-so's a scumbag and just leave it at that. That might be my opinion, but there needs to be a reasonable basis for that opinion in the first place.
Right, because one thing I've seen is I think people like to latch on to certain phrases which are magic get out of jail cards, which they aren't, and say, oh, it's my opinion, it's rubbish, rubbish, rubbish. So what you're saying is just prefixing it with my opinion also needs to have some factual basis as to why it's your opinion. Is that right?
That's right. So it's my opinion that such and such is rubbish because should be the structure. And then you explain why you've reached that conclusion. Now, an opinion doesn't have to be correct in terms of analysis by a third party. You can have a wrong opinion so long as the basis for that opinion is reasonable. Okay, so I think so. Using your example that a product was not very good, it might be that you've actually put it through a stress test that it's not designed for. And so the product itself might be very good for what it's intended to do. But if you haven't explained why you've reached that opinion, you might be getting into a bit of trouble in terms of defaming someone. Well, you can't defame a product. You have to defame a person. So with products, there's another area of law called injurious falsehood, which has sometimes been called defamation of goods. And that requires a false statement made maliciously, which results in financial damage. And that's an alternative to defamation. And sometimes if you're making a statement about a product and linking it to a company, so the company might sue for defamation if they're a small company, or the creator might sue you because you've linked it to that person, but they might also sue under injurious falsehood. They'll have two bites at the cherry sort of thing. The other thing to keep in mind is just because you've gone through these steps and you've made a statement, it's your honest opinion, you've got a reasonable basis for making it, it's not a total get out of jail free card. It doesn't mean that you can't be sued. Anyone can sue for any reason, in a sense. They might not win, but they will cause you a lot of financial harm by suing you. You'll have to defend yourself, ideally engage lawyers, and that will cost you money. And you might win the case, but you wouldn't get back everything that you've spent in defending yourself. So sometimes it's better to try and head the problem off at the pass rather than get into the brawl, unless you're financially well covered. And some people are. Rupert Murdoch, for example, has been sued in America. Now he can afford to defend himself, so he's not too worried. But the average Joe Blow probably can't afford to defend themselves. A typical court case in defamation could run easily for a week if it's a straightforward, simple case, and that could cost anywhere from 150,000 to 200,000 out of your own pocket. And if you lose, you'd probably have to pay the other side something similar.
Okay, so I've heard of a term called SLAP, which I think stands for something like it's an American term, I think, for a frivolous lawsuit designed to
strategic litigation against public policy.
Yeah. Now, is that something which happens in Australia?
Not so much, because of the fact that to sue in defamation, if you're a corporation, you've got to have fewer than 10 employees. It used to be that large corporations would sue for defamation because people would slag off that corporation, even though there was no merit in the litigation. So that was a slap suit. But because in Australia we've implemented, or the law says that you've got to have fewer than 10 employees, slap suits are few and far between. Still doesn't mean that it doesn't happen. It can happen from a small company.
Okay. So if a company decides that they don't like what a reviewer has done, they could send a lawsuit and act fewer than 10 defamation, or it's still injurious falsehood if less than 10, or both, above just injurious fraud. What should someone do when they get email, which is obviously frightening, saying, look, we are going to sue you? And I have had some of these. Typically they say, we don't like this, this and this. Here's all the things we want you to do. We want you to take down the content. We want you to walk around the block wearing sackcloth and ashes and apologise publicly and skywrite it and come and prostrate yourself at our feet in abject surrender.
Yeah,
exaggerate, but only slightly. So what should someone do when they get that sort of letter?
So the first step in a defamation is what's called a concerns notice, which is the sort of letter that you're describing. But it needs to be labelled a concerns notice. If it's just a letter saying, I don't like what you've said, that's not sufficient basis to bring a litigation against you. But most people will issue a concerns notice, and they will spell out in that concerns notice what their concerns are with what you've said and what they say that it means, what you've said means. At that point, you need to consider whether it's worth the fight. It might be prudent to take it down while you sort out what's going on, lest you create more damage, and try and engage with the other side and explain to them why you've said what you've said, and then see if that doesn't resolve matters.
So sometimes you get these letters, and I know what some content creators do. They just post them on the internet and say, hey, I've had this letter, and they mock and the letter and so forth, and basically go on the offensive. Now, I want to discuss the pros and cons of doing that, but also if typically these letters are marked privileged and confidential, and they say do not share with anyone else. So if you have such a letter like a concerns letter, what could happen if you decide to go the nuclear route and make a video about that letter, show it to everyone, and basically up the ante?
Yeah, the fact that something's labelled confidential and not for publication doesn't mean that that's in fact the case. You can publish it. You need to weigh up the gamble of is the other side serious, and are they likely to sue you? A lot of times when people put these up, they're calling the other side's bluff. But that's a gamble, and you've got to weigh that up on a case-by-case basis, whether the other side has articulated clearly a cause of action against you. If you get a concerns notice, it's always good to get an independent opinion. Go and see a lawyer and discuss it with them and see whether there's some merit in that case. But yes, I have seen that people put them up and try to cause even more damage that way, or shame the other side. And a lot of times it doesn't go anywhere. But as I say, it's a gamble.
Let's talk about professional indemnity insurance and what that is, and other types of insurance that can be done there. So please expand on that.
So professional indemnity insurance will apply if you're a professional. Now, a lot of content creators are hobbyists, and they probably might not get professional indemnity insurance. But if you're a professional, you're a journalist, and you have got professional indemnity insurance, that can cover you for defamation, so long as you haven't been malicious or reckless in what you're saying. So again, if you've got a valid defence, the professional indemnity insurer may well protect you or cover you for the costs of being sued. But they will take over your case if they're paying for it, and they may well say, look, let's settle. And settling might mean taking something down, especially if your case is borderline.
Okay. So as ever with insurance, merely having professional indemnity insurance is not carte blanche to say whatever you want to whoever you want and just throw opinions around freely, in the same way that car insurance won't cover you for stupid recklessness
Yes.
or illegal activities. You've still got to behave reasonably. What other types of insurances are there, or protections which content providers could put in place? Because so far we've said have your opinions, but make sure they're demonstrably backed up. Contact the company or whoever it is beforehand and discuss it with them. Have professional indemnity insurance. What else could content creators do?
Well, content creators, if they're publishing on the internet, they need to be careful about comments that are made by their readers or viewers. Those comments can get you into trouble. There was a case, the Volmer case, where a media outlet put an article up online that provoked comment, and some of that comment was defamatory, and the media company was found to be a publisher for the purposes of the Defamation Act. Even though they didn't make the statement themselves, the court held, and it was the High Court that held, that they had control over what comments were made. They could delete comments if they were defamatory. Um, they weren't. This comment wasn't deleted, and they had encouraged it in the first place. So you need to be careful that if you're making a negative comment about something, that others may well jump in, and what they say could be defamatory, and you could be responsible for their statement. They would be responsible as well. But often what happens is that a party that's suing will go for whoever's got the deepest pockets, or who they want to make an example of. So they might not sue the author of the comment, but they might sue the the product reviewer.
Even if the product reviewer, when notified, takes the comment down, etc., and gets rid of it?
Well, that's if they do it straight away. It depends how quickly they do it. If they take it down within a reasonable time of having been made aware of it, they're likely to have a defence, and be less likely that they will sue.
Yeah, because I can see the logic in this, but if that's the case, then no one's going to want to turn comments on anything, and then that really stifles a very, very valuable discourse for Australia. Now, I have seen, I think the ABC and the Guardian and some others actually publish and turn off comments, and I guess that's why.
Yes.
But few others do it. But if we've all got to do that, we are massively throwing out the baby with the bathwater, which is a great shame.
Yes. I can only agree with you. And unfortunately, that's the way the law has gone. There's not much I can do about that. It comes back to, again, what's your appetite for risk?
Okay, so if somebody is on Facebook or something like that, and then they write a lengthy post or even a comment about a product or service, and they could potentially get sued for either defamation or for injurious falsehood over that comment.
Yeah, injurious falsehood's much harder to prove because you have to prove malice in the statement, and you have to prove that there has been actual financial damage. It's rare that injurious falsehood gets up. Defamation has got to affect a small company or an individual, not just a product. But I suppose what companies or product manufacturers do is to say, well, you've slagged off my product, you're then suggesting that I produce dodgy products, and that therefore you've defamed me.
Because defamation is 10 or under and it's a lower bar to clear than injurious falsehood, there's an argument for only reviewing products from larger companies which cannot sue for defamation, can only do injurious falsehood, and therefore are less able to actually sue you.
Yes, I would agree with that. I would still, even if you're reviewing a product from a larger company, I would still stick with the basics of justifying your statements.
Yeah, absolutely. And the other thing is, in my experience, a large company will have professional media people there, and PR managers and marketing people, and they are not as emotionally invested in a product as the owner of a small company, who is typically the person who does 80% of the work and is quite likely to take something personally. And that's been my experience. Pretty much all of my trouble has been with small companies because of that personal nature, not the larger ones.
Yes, that's very true.
Now, what risk do administrators of social media groups run? So these are not content creators. These are people who just run a Facebook chat group and a
Mm,
discussion could break out. Are they at risk?
they can be. I think it's less likely, but if it's a question of whether that Facebook group, um, they're a publisher, and whether they've invited through one form or another comment about a product. Um, it's quite possible that they could get sued if they're an administrator of a group or the owner of a group.
Hmm.
Um, if you're a moderator, that's a bit different. I think moderators, so they're usually volunteers who don't own the group, but help out. They're less likely to be at risk or not at all. Um, but the owner of the group is the one who's potentially at risk.
All of this is applicable to Australia, but the world's international these days.
Mm,
So
mm,
YouTube's headquartered in the US. So, for example, I had one of my videos taken down because the car company in the UK objected to it. So they were based in the UK. YouTube was based in the USA, and I'm in Australia. So things get complicated very quickly. Whose law applies in that situation?
uh, it's going to be where the um, where the comment has been, if it's online, where the comment's been downloaded and read or seen is going to be the appropriate jurisdiction. If you're in Australia and you're making content primarily for Australian consumers, the likelihood is that the overseas company is going to sue you in Australia. Um, if your target audience is international, they may sue you overseas. Um, the problem that they would then face is if they won, how do they enforce it? They would have to then come to Australia and have the Australian courts recognise the judgment and then have it enforced in Australia. So there's less risk that way, I guess. Um, or it's more of a calculated risk with the international people. Organisations like YouTube and Facebook, they have their own policies, and so they might deem something risky or defamatory and take it down. But that doesn't necessarily mean that it is defamatory.
So let's say that I got a letter from a US law firm threatening to sue me in Delaware and I'm in
Mm.
Australia.
Mm.
Could I just throw that in the bin?
If you're not planning to go to America anytime soon, probably. The defamation laws are a bit different in America, and it's less likely that they would sue. They would be a large corporation. They probably couldn't sue you anyway. If it's an individual, um, consider whether they've got the resources to sue in the first place. Although in America there are law firms that will fund it on spec, but there's I'm not 100% familiar with US law, but I think that they've got provisions there for if something's made in the public interest, a statement's made in the public interest.
Okay, now if you're a product owner, let's say that you own a small business or you're a product marketing manager or something like that, it's in no one's interest to end up with a conflict between the product company and the reviewer. So what could the product owner do to ensure a smooth, fair, and reasonable review other than making a really good product no one can possibly
Yes.
define?
Well, engaging with the reviewer um, and try to understand why the reviewer has come to the conclusion that they've come to. You're right. Even if there is litigation, in the end, no one's a winner. Um, because reputations that the parties suing might create a negative impression of themselves. Even if they're in the right, the public might see that it's a David and Goliath battle and they're not being very nice about it. But engaging, I think, is the key for product creators.
Would you advise any form of contract between a product reviewer and a product supplier? And if so, what should it look like?
Once you get into a contract, then your review isn't really independent, is it? So, and I'm not sure what sort of contract you would get into. If there was a contract, it would probably have a clause in there that says you will not say anything derogatory, which sort of defeats the purpose if you're creating an honest review.
So often you are lent products. So, for example, Ford might lend me a car or something like that. Now, for lower value products, then you just get given them because by the time you've used them, box them up and sent them back, it's actually really not worth the effort to do it. So you arguably get given a product. So I've got a battery charger in my garage, for example. I was given by CTEC. Now, if that was worth $5,000, I'm sure they'd want it back, but it's two or 300 and it's really not worth me sending it back. Now, does the act of getting a free product like that create any obligations for the reviewer?
I don't think so. It depends on what conditions might have been put on the provision of that free product, which is a sort of entering into a contract, and what promises were made by the reviewer as to what they would do with the product. But just somebody providing you with a product saying, here's something for you to review, I think it should be understood that the review is going to be honest and genuine.
Yeah, so it's probably a good idea for the product reviewer just to make it clear up front to say, okay, you want to send me this product, that's fine. That means I will review it and I will create a draft. I'm happy to send it to you for comment, but I'm not obliged to change it. At the end of the review, I will either keep it or I will return it or whatever the deal is there, and essentially just say how it's all going to pan out.
Yep.
And I think it's probably a good idea for both parties to be clear on that. And if the reviewer doesn't initiate that, I think the product supplier should as well. But again, I don't see that maturity in the smaller companies who kind of expect all sorts of things.
Yeah, I think it's in the reviewer's interest to make it clear that they're going to review without fear or favour.
So you were the lawyer for the DCS Fischer case, very famous case now. What were the main learnings for everybody out of that case in terms of content reviewers and product reviewers and product owners?
Yeah, that case didn't go to a full trial, and it was Stefan Fischer won that case because of a technicality, and that technicality was that although the DCS saw itself as a small company and therefore able to be sued, it had links to another company which disqualified it from bringing an action. Nevertheless, we were prepared to go to a trial and put DCS to the test that they suffered some financial or serious harm. And we were confident that we could defend Stefan Fischer's comments. He included in his videos the basis or the test reports that he produced, which led to his comments. So he made it very clear why he was saying what he was saying.
Yeah, so that was so the question then comes is, how did DCS not know that they were likely to lose this? Or maybe they did know and went ahead anyway to lose on a technicality like that.
I think that they didn't consider it.
But that's kind of a really basic point of law, isn't it?
Yeah, it is. But it was a little bit of an obscure provision within the Corporations Act in terms of what constitutes a related corporation. Um, and I think they were, well, who knows? Maybe they were advised and decided to take the risk anyway, or maybe they were ill-advised. I don't know.
Okay. What else could we learn out of that case?
That litigation's expensive.
Okay, so even though Stefan won,
Yeah.
he's not going to be able to recover all of his costs anytime soon, is he?
No, he's not. Now, I mean, Stefan was in a lucky position or a good position in that he had a lot of followers who um, were prepared to stand by him, and he had a GoFundMe campaign which helped to cover his legal costs.
So what that says is being right isn't a defense against being sued.
Yeah.
And if you're sued, even if you are right, pure as the driven snow, you're likely to be financially hit. And for the people who follow anybody, such as myself or Stefan or anyone else who does this, it does help to support it, because then that gives us the confidence to know that, well, if the worst comes to the worst, my followers hopefully will be there for me, because if that doesn't happen, then we're going to, the art of independent reviewing is going to dwindle to nothing. And that's a hurt for everybody, because everybody wants an independent who can say, hey, I've got this bit, guitar or full drive or a mouse or whatever else. We want that. So I think that's the message for people.
Yeah, indeed. And in fact, the thing to be aware of is that you're right in that you don't get back, even if you win, you don't get back all your legal costs. You can you can expect to get back 60 to 70% of your costs.
Well, why is that? Why is it not 100 for not only the costs, but also, I know Stefan put many, many hours of his
Yes.
personal time into it,
Yep.
and emotion and everything else. So even if he got back every cent of an invoice, that doesn't compensate for all the other
No.
time and effort and pain spent. So why is it not 100% and plus?
The reason it's not 100% is because the legal system, the courts, have what's called a scale of fees. The best analogy is Medicare. When you go and see a doctor, if the doctor's not bulk billing you, they're charging you, say, $90 for a consult, and Medicare only gives you back $43. That's the scale fee, $43. They say that's what you should have been charged, or that's what we're prepared for you to receive back. Now, the legal system does a similar sort of thing. They say for a document that's of this size, we say that you should only get back this much for it. And that works out to about 60 to 70% of what the real costs are. Lawyers charge more than the scale fee.
That just seems grossly unfair to me, because it just means that if you've got deep pockets, you could just use that as a hammer. And as we said before,
Yep.
knowing you're going to lose, you don't care. You're going to go, well, I can just lose 40 grand on this. I don't care. If it costs me 50 and it hurts this guy by 20 grand or whatever,
Yep.
that 20 grand means more to him than the 50 or 100 does to me. I don't care. I'll just use the hammer.
That's right. And that's why it comes down to what's your appetite for risk.
I think this video is going to scare a lot of people off content creation in the first place. But I think if we just bring it back to the point here of being factual and backed up,
Yep.
I think that's important. Now, let's talk a little bit about indemnity insurance. So, if Stefan had had indemnity insurance, would that have covered his costs completely?
Well, it depends on the insurance policy, but I think that it would well have gone a long way towards covering his costs, if not covered them entirely. Yeah, so the insurer might get to a point where it's prepared to settle the case, and those settlement terms might not be entirely what you want. And the insurer will say, well, we're prepared to settle this case. We'll cover all the costs for these conditions. And if you say you don't agree, then you can run the case yourself.
Hmm. Okay, so
Same with motor car insurance.
yeah, okay. So let's think about this. Let's say that I've made a video and it's a product review. I've been sued over that, and the insurer takes over and says, okay, we're going to fight that battle. And I go, okay, that's fantastic. Now,
Mm-hmm.
the company in question goes, we want as this video taken down, but we also want Robert's complete YouTube channel to be deleted, and we want a public apology, and we want to make sure that he never says a word about any automotive product again for the next 5 years. And
Yeah.
the insurance company goes, well, that's fair enough. Can
I,
they?
well, I would probably be having the debate with the insurance company.
No, no, but could the insurance company agree?
Theoretically, it could.
Yeah.
Theoretically. Um, I would think that they would be reasonable, though. Some of the conditions that you cited, like you're never going to work in the industry again, would be not reasonable. Um, so it depends how targeted the settlement is to the actual conduct that occurred.
But could the judge or whoever else step in and say, look, what you're asking here for a settlement is actually a bit crazy. Yes, he should take the video down. Yes, apologize. But to get him to the whoever it is to do all of that beyond is just would the judge go, just step in and say this is crazy?
No, settlements occur outside of the court system. So the way a settlement would work is you would negotiate, the two parties would negotiate with each other, come to an agreed set of terms, and one of those terms would be that the case is discontinued and that the other party agrees to that. And the judge will never know what the terms of the settlement were.
Okay, so in theory it could happen. In practice, does it happen? Because I'd like to make a distinction between theory and practice.
Um, Sorry, does what happen? That
Yeah,
you
the example I've given here of I've made a video which has been deemed defamatory or injurious or whatever, and an insurer goes, yeah, okay, we're on a losing here, and then the company in question says, we want that video taken down and we want the entire YouTube channel deleted and his website and his Facebook page and
Mm,
everything.
mm.
The insurance company could go, well, that is actually the cheapest and easiest way out for this, because then this problem just stops right here and now.
Yeah, I would be surprised if the insurance company agreed to those sorts of terms.
Um,
Uh, that goes beyond um, the actual defamatory situation. Yeah, I would be. I think yeah, it's outside. It just goes too far.
yeah, I mean, the only defense the creator would have would be that would really kind of give the insurance company a very bad reputation.
Mm,
But then again, the insurance company could say, look, as part of this deal here, you're not allowed to speak about this case. And when you're facing hundreds of thousands of dollars, which people typically do not have,
yeah,
it's going to be, okay, well, I can sign this deal, indemnify my professional indemnity insurance company and this company, and I'll just go and hide in a hole for the rest of my life because that's kind of preferable to losing everything I've got.
yeah. I mean, if you want to go down that path, you can, but I would think it's worth the fight
Mm.
not to. if you had sort of those unreasonable conditions. There's not a lot of court cases with content creators being sued. I think a lot of them probably fold early on in the piece and you don't hear about it.
I have seen evidence, and I've seen it myself to me, of those slap suits we talked about.
Yeah.
Just there. Is that a common technique used in the legal profession to intimidate people into compliance before anything's done?
No. Certainly, it's a generally accepted principle, and it's mandatory in Victoria, that there has to be a proper basis for bringing a legal action. You can't just do it on a whim or just to intimidate. There's got to be some proper basis to say that the law has been broken.
Okay, so and does that include sending of a concerns notice?
Yes, I would say that's right. And the lawyer generally has to sign off on that. So they're risking their own professional reputation.
So if I got a concerns notice, which I thought was spurious,
Mm,
I could conceivably go to the Council of Lawyers and say, hey, I've got this and here's the deal. And that lawyer could potentially be investigated for making an unreasonable claim.
I suppose in theory, yes, but it's unlikely, because there will be an argument. The lawyer will have an argument as to why their case, to justify the letter. The proper basis principle really comes into play with litigation. Courts don't like being tied up on spurious matters. But threatening letters, yeah, they happen.
Okay. And what is kind of I guess, the burden of proof for injurious, well, let's go defamation
Yeah.
first.
So it's a civil case, which means that it's all on the balance of probabilities, more likely than not.
Okay. So for defamation, you've got to prove that your reputation was damaged.
Yes.
And
And you suffered serious harm.
what serious harm?
Well, that's going to mean, so serious harm's going to be something like, the defamatory statement was published to a large number of people. There's a grapevine effect, which is that people see the comments and then talk to others about it, and it just gets pushed on and on and on. Meaning that then more and more people have seen it. And if it's a corporation, that they've actually suffered financial harm. They can prove that they've lost money because of that statement.
So it's got to be all of them, right?
Yeah, so an individual doesn't have to prove financial harm. They only have to prove reputational harm.
Okay. But a corporation needs to prove financial harm and
Yes.
reputational harm.
Yeah.
And they've got to have evidence to that to say, hey, here are my sales before.
Yep.
My
Yep.
sales dipped, and not only did my sales dip, but they dipped because of that. So that might be, for example, people writing in to say, hey, I've cancelled my order because I saw this review, etc.
Yep.
That sort of
Exactly.
thing, right? So
Yeah.
they've got to have that. Yeah. Okay.
Yeah. Something I haven't mentioned is the thing, for product creators when considering, whether to bring a legal action. There's a thing called the Streisand effect.
Oh, yes, yes, yes.
And the Streisand effect is essentially that if you'd stayed silent, very few people would have known about the defamatory comment. But because you've brought a legal action now, a lot more people know about it, and you're actually harming yourself.
Yeah, I completely agree with that. And also your earlier point that even if you're the good guy, if you're a product owner and you are correct, suing someone almost always looks bad.
Yes, it does.
It's almost I struggle to think, and almost the worse defamation, the worse the defamation is by the reviewer, the less likely you should be to sue, because the more obvious it is that the person's just biased and ridiculous. So taking the moral high ground is certainly something that I would very much
Yep.
advise product owners to do, unless it's an ongoing sort of systematic that you go, okay, we need to take. In other words, it's, I think what I'm saying here is the reasonable person in a pub test, would public opinion swing towards you? Because I think that's really what it's all about for product owners there.
Yeah,
So,
yeah. And it's really going to depend on how widespread the audience is. If you're a major daily newspaper and you publish something, you've got a large circulation, and that can have significant effects. But if you're a YouTube reviewer that's only got a few thousand people, then it's probably not worth suing.
but wouldn't that be sort of a percentage of your base? So, for example, if one of my videos goes out and 30,000 people see it, that's not many in terms of, let's say, people that would want to buy a product at JB Hi-Fi.
Yeah, that's
if
right.
we look at the percentage of people who would want to buy, let's say, a new Ford Ranger, that's a much higher percentage, or some other niche product there. So it's probably, isn't it, percentage of your total target audience as opposed to total number of people?
That's a factor.
Okay.
But you can still have your reputation harmed even though you're not a purchaser. So it might be just public perception of that product, even though you're not going to be buying that product.
So massive thanks to PK for taking the time to talk to us. Please use the comment section to ask any questions, and we'll see if we can get them answered. Thanks for watching.